Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are talking about some founders. We've got three of them, and these three founders decide that what they'd like to do together is they'd like to incorporate a company. And what this company is going to do is it is going to commercialise an idea for authentication and identity technology. It's sort of high-tech stuff, the CSIRO is involved and all this sort of thing. And the way it's going to work is each of our three founders is going to be a director of the company, and each of our three founders is going to have their own company, their own entity, that's going to own shares in the company. And what happens shortly after the incorporation of the company is there is a deed entered into, and parties to that deed include each of our founders, each of our natural persons, our sort of flesh and blood and bone persons, and each of those persons' companies. So we've got an agreement between James and James Pty Ltd, as well as Blogsy and Blogsy Pty Ltd, and that sort of thing. So each of the natural persons and each of the companies are involved. Now, what happens is our plaintiff for today takes a role as CEO, the Chief Executive Officer, the boss running the operations of the company, and takes that role, not quite reluctantly, but in the absence of other applicants and in circumstances where the newly formed company needs someone to go and run it. And things start bubbling along. Now, what is interesting, and I'll just flag for you at this stage, is that notwithstanding the existence of the deed, there is also what the plaintiff says an understanding about equal shareholding. So there's a reference in various emails between the founders to us having a communist model and an animal farm style, sort of being communist piggies and that sort of thing. And the implication, the plaintiff says, arises from that is that there was an agreement between each of the founders that each of them would have equality of shareholding, and that each of those shareholdings would remain equal over the life of the venture. Now, one of the plaintiff's claims was that the shareholding eventually became unequal, and that was a breach of this equal shareholding understanding. Now, what the court did was disagree with the plaintiff and agree with the defendants. And the reason the court agreed with the defendants that there was no equal shareholding understanding was that, firstly, interestingly, the plaintiff hadn't actually put on any evidence that was sufficient to convince the court that there was a sort of equal shareholding understanding. Secondly, the operation of this deed that everyone entered into allowed for there being unequal shareholdings between parties. So parties potentially acquiring more shares, parties potentially divesting themselves of shares. And of course, if you and I start off equal and I get some more and you don't, then our shareholdings become unequal. Or in the alternative, if you and I start off equal and I divest myself of some shares, or someone new comes on with a different level of shares, which is what the shareholders' deed allowed for, then that equality understanding could not have been so. And even if both of those things were wrong, what the court also found was that the deed included an entire agreement clause. And an entire agreement clause is something that many lawyers will be familiar with, that essentially says, hey, this document is the entire agreement. It's everything between the parties in relation to these issues, and so anything outside of this agreement falls away and is superseded by the deed. So the plaintiff goes down on the equality of shareholding point that they'd planned to bring. Now, there are other claims raised as well. And what's interesting is that these claims were raised in the context of not the plaintiff themselves, their sort of flesh and bones themselves. It was raised on behalf of the plaintiff's entity, right? Because remember that the relief under Section 232 of the Corporations Act is what we might call pretty bluntly shareholder relief. And as you might imagine, the only people who can seek shareholder relief are shareholders, and our flesh and bone plaintiff, as we referred to them today, is not the shareholder, it's the plaintiff's company, but we'll sort of use the term plaintiff and plaintiff's company interchangeably. Apologies if that gets a little confusing as we go on. If we're going to understand the plaintiff or the plaintiff company's application regarding corporate oppression, I'm going to have to tell you a bit more about some of the travails of operating the business. Now, the plaintiff over time gets frustrated with the lack of engagement in the operation of the startup company from one of the other founders, one of the other directors. And the really short point is they don't get along. The longer point is there are reams of emails and lots of exchanges about some of those issues that can arise in business disputes that might seem quite petty, like the placement of tables or the sort of politeness of emails and that sort of thing. But what emerges is what the court describes as a burning frustration on the part of the plaintiff with the conduct of the first defendant. And over time, this burning frustration goes beyond a interpersonal feeling and into a genuine inability really to engage with each other. And things bubble along, and the plaintiff continues as CEO, and it's challenging. And there's one moment where the plaintiff goes to America on a fundraising tour to attempt to try to bring some investors into the company. And during that fundraising tour trip, a holiday, working venture, what happens is that our first defendant and second defendant as well, who's attempting as well to be a bit of a mediator between these two personalities where they can, causes a new CTO, a new Chief Technology Officer, to be appointed, who is not the CEO's preference, and for some of the CEO's pet projects to be discontinued. And so this sort of undermines the CEO's authority. Now, what happens after this is that the CEO offers their resignation. This is the plaintiff as CEO offering their resignation. That's rejected a couple of times by the second defendant, who's attempting to sort of coax an outcome out of this relationship, but it doesn't quite go that way. And what the plaintiff company, I withdraw that, what the plaintiff's company attempts to do, remembering that it's the plaintiff's company who's the shareholder, is to say, hey, the way that the CEO, the plaintiff, was treated was oppressive. And the nature of that oppression was such that, thank you very much, was such that I, as the company, ought to have some relief in respect of it. Now, what's interesting is this. The plaintiff company's rights as shareholder include rights pursuant to the deed to appoint a director, but they don't include rights that are, for example, you can appoint the CEO and that CEO should have a very smooth ride. And so what the court found, apologies for the slight looseness of language there, but what the court essentially found was no. The conduct of defendant one, while not especially impressive in a number of ways, was not sufficient to be oppressive, unfairly prejudicial to the shareholding rights of the plaintiff's company. Now, there were a number of other complaints raised by the plaintiff's company in respect of the way the company was managed. So let's get into them. As 2019 wore on, what happened was that the plaintiff had resigned as CEO and they'd engaged a new CEO hoping to smooth things over. That didn't go so well, and what happened is that defendant 1 and 2 arguably, or in the plaintiff's view of the world, arguably together, the plaintiff might say, caused the acting CEO to be fired abruptly on Christmas Eve in 2019. Now that was in circumstances where the acting CEO's contract had, on one view, sort of expired in late November and was sort of on a week-to-week, month-to-month basis from there. So there were arguments about that. But in essence, that leads the plaintiff in his capacity personally as director to resign as director in January of 2020. So they, in their personal capacity, have resigned as CEO. They, in their personal capacity, have resigned as director. But don't forget, their company remains a shareholder. And their company has raised this firing and resigning as CEO as potentially oppressive. Section 232 of the Corporations Act, the court does not agree that that is oppressive. Now, there are other claims to be brought as well by the plaintiff company in relation to some of the conduct of the defendants. Some of that other conduct relates to the issuing of shares and the issuing of options. Now, over time, as I understand happens in a number of startups that might be a little bit low on cash, these issues arise where the company needs capital, the company needs to retain its existing staff or attract new staff. The plaintiff themselves was bringing sweat equity in the company. It wasn't bringing cash, it was bringing hard work. Remember, they had a role as CEO. And the plaintiff also had resigned from the board, so had stood away from operative issues like the issuing of shares. So in this sort of circumstance, what happens is share issues are considered, or to put another way, the issues of shall we issue some new shares come onto the agenda. And what happens is these wage loans that I might have referred to earlier, but where our directors, in lieu of being paid directors' fees, have loan accounts built up in the company. So let's say I'm paid $5,000 a month for directors' fees. I elect in a startup not to drain the cash out of the company. I say, hey, look, just record those as a loan, and the company will pay me back eventually, because we're all going to, make $1 trillion, and when we make $1 trillion, I'll have $1 trillion plus this loan account, essentially. And so what happens is a resolution is passed, and it is passed by Defendant 1 and Defendant 2 as directors. Remember that the plaintiff has resigned as director. And the nature of the resolution is that the wage loans, if we describe them as the way the parties describe them, are converted into shares. So we stop recording a loan to the directors and we go, hey, look, loan gets forgiven. Let's issue some shares in your name, my name, and we'll even things out that way. That resolution is passed, and what Defendant 1 and Defendant 2 do is they do that for their loans, so they get their shares, but they don't do it for the plaintiff's loans. There's no explanation given for that at all, and the court says, yeah, that's oppressive. There are some other issues that arise. The plaintiff company complains about the issue of options to a very senior staff member who actually is CEO at some stage being provided with options. And as you might imagine, the provision of options in the absence of the plaintiff having a role to decide about it is just Defendant 1 and Defendant 2 saying, hey, let's give this person an option to have some more shares in the company. The effect of that, of course, is going to be to dilute the other shareholders' shareholdings. Now, what the court says is, noting the commercial scenario the company found itself in, needs capital, wants to retain senior staff, this sort of stuff, that it was appropriate that these options be granted to the CEO, and further, that a court is always going to be loath to come and second guess the commercial decisions made by experienced business people. So it's going to be fairly unlikely a court's going to sit in there and backseat drive in quite a minute way decisions like this, and indeed, this is not the example of a decision that the court elects to backseat drive, if we're going to use that loose expression. There are other similar share options that are found not to be oppressive, and so we have this scenario where the plaintiff has brought this claim about equality of shareholding, that fails, claim about oppression for the way the CEO was treated, that fails, claim about a number of options and issuing of shares, that fails, but one claim about these wage loans that is successful. And what the court says is, you've got our thoughts on the position, go away and agree between yourselves on the appropriate form of relief that ought to be granted to the plaintiff or the plaintiff company. Come back another day and we'll talk about it then. I hope that very long discussion assisted you, and I look forward to joining you again soon for another coffee and another case note. Cheers.